Good evening, everybody. Today we have a special speaker, my personal lawyer, Mr. P.S. Ranjan. Mr. Ranjan, okay, is a well-known, famous lawyer, and he wants to be a stand-up comedian. But today we're giving him time to tell us about cases that he is going to share with us. Medical legal cases. So, Mr. Ranjan, go ahead.
Thank you, Dr. Betty Tay, for the introduction. I thank the organizers for inviting me to speak to you tonight on this subject. I understand that since signing in into Zoom is limited to a certain number of people only, yes, that you can get access to this talk through Docquity and also on Facebook. Arrangements have been made. I propose to discuss a handful of cases and make some observations regarding them. And I hope that you would feel sufficiently informed about the interaction between medicine and the law, not always with a good result from whichever point of view that you look from. Right. Now, I would like to go to the next slide. So I propose to touch particularly on issues like subjects like malpractice, professional conduct, the protection of people, especially the vulnerable, and the public interest. Let us see next about what negligence is about, because one of the subjects that we are going to discuss today would be negligence. There must be the existence of a duty of care to a neighbor. That's a term we lawyers use. Breach of the duty, damage caused by the breach, and that the damage is reasonably foreseeable. So these are important elements. If I may give the analogy, say when you're driving on the highway, it is dark, it is raining heavily, and your car's windshield wipers are not working properly, and one of the headlights is not functioning at all. If you were to continue on the journey, it would be reasonably foreseeable that you would meet with an accident. So that's something I would like you to think about, that knowledge of the facts may make something reasonably foreseeable. I would like to tell you of a true story, nothing to do with medicine and the law, about foreseeability. About 50 years ago, a lady in Czechoslovakia decided to commit suicide because her husband had left her for another woman. She jumped off a building and landed on a passerby. She survived. Her husband died.
No, the passerby died.
Yeah. Oh, it was her husband.
Oh.
The passerby was her husband. Now, okay. So the question, was it reasonably foreseeable that she would land on her husband? So some things are not reasonably foreseeable. The law of statistics may be such. But the moral of the story, when a man walks down the street, he should look up once in a while. Right. Let us move on. Damage can occur out of a doctor's acts or omissions, but liability cannot arise unless there is fault on the part of the doctor. And I emphasize the word fault. There can be medical accidents where there is no fault. So there can be situations where the doctor acted with due care and skill, yet damage arose. But in court, it would be said that there was no negligence as a result. Let us go on. So I'd like to tell you of a successful medical negligence claim. It is a landmark case, Chin Kiao, in the government of Malaysia. Before cases like Chin Kiao, people in Malaysia and Singapore hardly thought about medical negligence. Lawyers hardly thought of taking up against healthcare providers a claim in negligence. So this was a landmark case, something new. It was undertaken on behalf of the patient's family by one of the finest lawyers that Malaysia has produced, Miss P.G. Lim, a brilliant lawyer, and I have a lot of regard for her. Now, what happened in that case? The patient was a government clinic attendant with a history of allergy to penicillin, who died after receiving a third injection of penicillin. First of all, in 1955, she received the first injection. No harm arose. In 1958, she suffered an anaphylactic reaction to the second injection of penicillin in the same clinic. So her immune response system had overreacted in a very violent way, but she survived. So an entry in the notes, allergic to penicillin. And I say she was apparently cautioned about it. Let's go on to the next slide. All right, let me get the next slide in. In 1960, she was working in the Sultan Street Clinic in KL. Wait, I think we skipped one. So let's go back to the previous one, all right? One day, she told a nurse that she wanted to see the medical officer on duty because of a painful swelling on her thigh. She also told the nurse that she wanted to speak to him about penicillin. Now, this was a point which emerged during the trial, but which the Privy Council did not mention. But it's an important point. So keep in mind, the circumstances in those days. She was a clinic attendant at the bottom of the hierarchy. The medical officer was at the top of the hierarchy. She would have been deferential to him. She would have gone to an intermediary like the nurse to say that she wanted to see the doctor. And she mentioned to the nurse that she had something to say about penicillin. The nurse should have been alert to that point. It turned out the medical officer did not ask the patient about penicillin. Whether the nurse told him about it or not, we don't know. I mean, she may have told him. Maybe the nurse decided not to tell him, but important point is the medical officer did not ask questions. If he had asked, you would likely have found out about the history of an allergy to penicillin. So then it would have become reasonably foreseeable. I emphasize those words, reasonably foreseeable, that if she received an injection of penicillin, she would suffer again an anaphylactic reaction. But the doctor did not know. The patient knew, the doctor did not know. Asymmetry of information, but the doctor should have known. That is the point. So the patient died after receiving the injection of penicillin. The mother's claim succeeded in the High Court, but the federal court reversed the decision. The federal court was somewhat doubtful about the expert opinion given on behalf of the mother's side. The mother brought the claim. The expert was the distinguished family medicine practitioner, Dr. Tan Chi Kun. And he supported the claim. He said that there should have been questioning of the patient in the circumstances. The federal court said that, well, Dr. Tan Chi Kun is not a professor of medicine, etc. He has not written great medical textbooks, etc. And therefore, his opinion could not be said to have been supported by the leaders of the profession and great medical writers. That's what the federal court said. So the claim was, the court decided that the claim should not succeed. Then it went to London, to the Privy Council, but the Privy Council disagreed with the federal court. Let us look at the next slide. So, in the Privy Council, central to the finding of liability, the failure of the medical officer to ask the patient as regards whether she had a history of an allergy to any drug. Right? Second bullet point I mentioned, the allergy was already known to the patient. It would have become known also to the medical officer if he had asked her the necessary questions. Therefore, applying the test of foreseeability, it was an avoidable accident. And the Privy Council said about the federal court's treatment of the expert evidence of Dr. Tan in support of the claim that the federal court had set an unacceptably high standard. There was no need to apply such high standards. The standard was that of the ordinary competent practitioner and not of someone of a higher standard. And Dr. Tan was an ordinary competent practitioner, and that was good enough. Sometimes, doctors tell me when an accident has happened in a hospital or in a clinic, I did my best. Unfortunately, doing your best is not good enough if the best that you can manage is below the standard of an ordinary competent practitioner. That is vital. So it's not just a personal standard, my best. It must be an objective professional standard of the ordinary competent practitioner. So the claim succeeded. Following Chin Kiao, there were a handful of other medical negligence cases in Malaysia in the 1960s, usually without success. But times have changed. Yes, we can see now that the ratio of, say, successful claims as against unsuccessful claims has been rising. So there are various reasons for that. Amongst them would be that patients are more aware of their rights. They've got more resources in terms of, say, having lawyers, having experts, having access to medical courts, etc. Also, there is a greater willingness on the part of the authorities, like the courts, on the part of experts too, to question the actions of doctors. Now, I also make this observation. I cannot go beyond this. Certainly, we do see some uneven standards in healthcare in this country, Malaysia. And when there are uneven standards, then there can be room for criticism of, say, the actions of healthcare practitioners. Another reason why there is, say, more success now for claimants in medical negligence is that the courts have applied certain rules of law which make it easier for claimants to make their claims and to succeed in their claims. Let us move on. Let us move on to the, all right. So the Bolam test, it was meant, Bolam was cited in Chinkiao. Bolam test is named after an English case. So there would be no liability on the part of the doctor concerned by an informed body of medical opinion. But it must be kept in mind, there is room for differences of opinion, informed opinion. And negligence cannot be found by preferring one competent expert opinion over another competent one. However, it must be kept in mind, Bolam is not relevant in cases of administrative and clerical errors which cause accidents because no special skill is involved. I give examples in brackets here. Wrong patient names, misfiling of documents, retained forceps, errors in swab counts, images marked the wrong way around in cases of symmetrical anatomy, etc. So, in these kind of situations, expert opinion is not particularly relevant for the purpose of finding fault. Now, for a long time, the test in Bolam applied to all aspects of a doctor's duty of care. One, as regards diagnosis, two, as regards treatment, and three, the giving of advice and information to patients or their guardians. I would like you to keep in mind that point number 3, the giving of advice and information to patients or their guardians, because cracks appeared in the wall of the Bolam defense. It is not just a test, it is a defense. At this stage, I pause to ask doctors, if you have the Bolam test where really, support from your peers is helpful in defending a claim, how about this? If you, a doctor, were to sue your lawyer or your accountant for negligence, would you like to have a Bolam type of defense raised by your lawyer or your accountant? Think about it. Let us move on to the next slide. Cracks in the wall, I said. I mentioned the Australian case of Rogers and Whittaker, but I would like to mention the early start provided by Lord Justice Carman. He was the lone voice in the UK case, Sidaway and the Bethlehem Royal Hospital governors. It was a case of spinal surgery. And there, a lady underwent spinal surgery and suffered neurological injuries because of injury to certain nerve roots. The patient's lawyers specifically put into court this point, that the operation was performed carefully and skillfully. Important point, carefully and skillfully. So they were not there to fight with the surgeon about treatment, about his surgical technique. But what they said went wrong was that the surgeon did not give sufficient advice and information to the patient as regards a material risk of injury that could arise in the operation. So the majority of the judges, 4 judges in Sidaway, said the Bolam test applies. What the ordinary competent doctor thinks should be told to the patient is what we expect. I am oversimplifying things. Please keep in mind that they more or less supported the Bolam test. Lord Carman said, no, the Bolam test should not apply. It should be a patient standard that should be applied. So, and that's what Lord Carman said. But Lord Carman went on to say
Wait,
though
Mr.
that
Ranjan, can you explain to us the Bolam test again in a brief, concise way? Because I'm slightly lost.
okay, the standard is whatever a doctor says or does is to be judged according to the Bolam standard, and that is the standard of the ordinary competent doctor.
Okay,
If it's a specialty, the ordinary competent specialist.
okay. So that is the
Right.
Bolam test, the Bolam
Yes,
standard.
yes.
Okay.
So, yes. But the first crack in the wall, one of the first ones, I mean,
Okay.
there were already signs in jurisdictions like Canada, Lord Scarman and some American states, but Lord Scarman said, no, it should be the patient standard. It should not be decided by doctors what and how much to tell a patient. Because, you see, things like this, the doctor may be concerned with clinical issues. The patient will be concerned with non-clinical issues. Will it affect my speaking voice? Will it affect my career? Will it affect my appearance? Is it going to be very expensive? All these things can come in. Non-clinical issues. So, there is some basis for supporting the patient standard there. But Lord Scarman went on to say, though, even if the patient standard were to be applied to that case, it was not shown that the patient standard was not met by the surgeon. So, whichever way, whether it's a doctor standard or the patient standard, Lord Scarman said, unfortunately, the patient won't succeed. Not enough evidence to show that this is what the doctor, the surgeon, the neurosurgeon concerned had failed to say to the patient. Anyway, the claim failed. I remember a medico-legal expert in London sent me the judgments, the opinions expressed by the judges in Sideaway. And he remarked, this is about 30 years ago, that even though Lord Scarman was out on a limb, it was possible that one day his views would be accepted. So, and in fact, that's what happened. His views were accepted later. Now, let us see. First, in Rogers and Whittaker in Australia, a lady underwent surgery on her eye. There was a failure on the part of the ophthalmologist to warn her of the risk of sympathetic ophthalmia occurring in the other eye, which was her good eye. Bad eye and good eye. What happened was, the operation failed, even though it was carefully and skillfully performed. So the bad eye remained bad, but sympathetic ophthalmia, a 1 in 14,000 risk, materialized, and the patient became blind in the other eye. So she became totally blind, the worst possible outcome for the patient. Now, when he went to court, the patient's lawyers argued that the patient standard should be applied when it came to warning of risk. What would the reasonable patient want to know? What would that particular patient want to know? And there was evidence that she had asked questions like, would anything happen to my good eye? The defense argued, no, it is the doctor's standard which should apply. What would the ordinary competent doctor decide to say? And the evidence was that the ordinary competent doctor will not warn of this risk of sympathetic ophthalmia being materializing. Will not warn. But the judges in Australia refused to accept the patient standard. They said refused to accept the doctor standard. They said they will accept the patient standard. And so that's how things developed in Australia. And then came a break in the wall came down insofar as advice and information is concerned. Let us look at the next one. So the Montgomery case in the year 2015, there a young mother during her pregnancy was not advised about the option of she undergoing a cesarean section. A vaginal delivery was undertaken. The baby suffered shoulder dystocia, which caused a brachial plexus injury. And also the baby suffered a hypoxic insult, as a result of which the baby had this condition, hypoxic ischemic encephalopathy. An awful result. So the claim failed at the two or lower levels of the courts. When it went up to the Supreme Court, the claim succeeded. The Supreme Court said that the patient should have been warned of the risk of a vaginal delivery. She should have been given the option of a cesarean section. On the doctor's side, the experts argued that no, it is a doctor's standard which should apply. It was not the practice to warn patients of the risk of injury arising from a vaginal delivery. It was not necessary to offer her the option of a cesarean section. But the Supreme Court rejected these arguments. They followed Rogers and Whittaker, accepted the patient standard as set out in Lord Scarman's opinion. The Supreme Court was concerned there with advice and information. So the competent doctor standard continued to be applied to matters of diagnosis and treatment. But I must tell you, it must be the standard of a competent doctor. And experts who come to court must show their competence before their evidence can be accepted by the court. Let us go on. Right? About experts. Healthcare experts are frequent witnesses in court, not necessarily in medical negligence. They appear in a variety of situations, criminal cases, murder, say voluntarily causing hurt. There can be, say, defenses like insanity, which may be raised. The needs of a child may require medical evidence in, say, divorce proceedings. There can be disputed wills, and the medical evidence may be relevant, for instance. So doctors get called to court in a variety of cases. Right? So the administration of justice requires the support of sound experts. Next slide, please. Let us look at it. Chew Nang Hong and public prosecutor. The events took place, I think, around 1960. By the time he reached the Privy Council, some years had passed, a young married woman alleged rape, but a successful defense was raised that she had given her consent. She said in court that she was, quote, threatened with violence, unquote, and was, quote, overcome with fear, unquote. The defense expert was Professor Benjamin Henry Shears, who later became president of Singapore. He gave opinion evidence in support of the defense. Next slide, let us look at it. The Privy Council said, quote, the doctor's view was that it was unlikely that she would be able to give such a detailed account had she been in a state of shock because of what happened, unquote. So, much turned around this question whether she had given her consent. And the medical evidence was relevant. Right? So that is about Chew Nang Hong. Next, we'll look at the next one. about professional misconduct. And there is growing attention by the disciplinary authorities and the criminal courts too. Disciplinary authorities, like for instance, the Malaysian Medical Council. There can be disciplinary proceedings undertaken, say, by the Ministry of Health against its medical officers. Such things can arise, yes. And we have seen some instances of such proceedings. Let us look at this one, next one, about the misconduct of experts. And let us look at this one here. The next one is about Professor Sir Roy Meadow, a consultant pediatrician. Because of him, because of his unsound evidence, a number of innocent mothers ended up in prison. They were found guilty of having killed their babies. How did it all begin? Let us look at the next one. Professor Meadow advocated Munchausen syndrome by proxy, also known as factitious disorder imposed on another. What is it about? It's a rare condition, of course. People harm babies and young children in their care so as, for instance, to draw attention to themselves. In fact, once at a forensic sciences conference, I watched during a session a video clip showing a mother hitting her baby in the room in the hospital where the baby was. The doctors became very suspicious, of the mother, and that is why they put up a secret camera, because they suspected that the mother was up to no good. Now, you may say this was all very intrusive, it was done without consent, etc. But this was truly an exceptional situation, and acting in good faith, they went ahead and did it. And I think they acted ethically in doing so. So what happened? Because of Professor Meadow, a number of mothers ended up in prison because of his faulty expert evidence, including an abuse of statistics by him. He was not qualified in statistical analysis and interpretation. So how did he go about it? He said, oh, there were 2 deaths, 3 deaths, say, in the same family. So one death may be seen as a tragedy or something. Cannot be blamed, say, on the mother. A second death would be suspicious, he said. And then he said that the third one, even far more serious a situation, the mother must be blamed. And he came up with some awful statistical analysis saying that the odds of there being no fault on the part of the mother was so uncertain. It was just not possible, he thought, in the circumstances. So he blamed the mothers. Now, he did not think about this. Congenital factors, genetics can play a part, the environment can play a part. So if each baby was subjected to the same genetic anomaly, subjected to the same environmental harm, the odds of another death occurring in that family would have been even better. He did not address this point. I think there were other points too. But anyway, it was shown that he had got it all wrong. So a number of mothers were eventually freed. But can you imagine, at great cost to themselves? Some of them went into depression. One mother died an early death because of alcohol poisoning. She was a very depressed lady. All these things happened. Let's look at the next one, please. Professor Meadow was taken before the General Medical Council for misconduct, but he narrowly escaped punishment. In fact, the General Medical Council found him guilty. He took it up on appeal, and by a 2-1 verdict, the Court of Appeal in England found him not guilty. But then what did he do? He removed himself from the register so that no further complaints could be made against him. But what a sad story. Next one, please. Let us look at this. The need to protect the vulnerable. Here we see the conduct of an honorable obstetrician, a surgeon. He protected a vulnerable girl. Let us look at this. The Crown and Bone in 1938. Surgeon Mr. Alec Bone performed the termination of a pregnancy on a 14-year-old girl who had become pregnant after having been raped by some soldiers. Now, the law at that time provided that termination was allowed for the purpose of, quote, preserving the life of the mother, unquote. Now, in the Indian Penal Code and the codes in a number of other British colonies, the words were, quote, saving the life of the mother, unquote. A much stricter requirement. Lawyers, they are fond of using, words in various ways. Preserving, saving. Saving is something far more, shall we say, demanding a term. So Mr. Bone went ahead and performed. In fact, he openly said he was going to do it. And there were people who were against it, people warning him that he'll be arrested and charged. And in fact, he was arrested and charged. He was found not guilty by the jury. Next slide, please. Let us look at that. The judge directed the jury to decide whether the pregnancy was terminated so as to prevent the girl from becoming, as Mr. Bone asserted, quote, a physical or mental wreck. So there was a clear distinction between saving life and preserving life. That there he was trying to preserve the life of the mother. It was not about saving her life. So there's a lighter burden when it comes to preserving life than when it is for the purpose of saving the life of the mother. Let's go on. The All England report, and it's a law report, editorial comment, quote, the judge carefully distinguishes between danger to life and danger to health, and between the act of a professional abortionist and an operation openly performed by a qualified surgeon. So these were important points. Then there was this Malaysian case, Dr. Nadesan Kanagalingam. The distinctions drawn in Bone were not discussed by the judge of the High Court in the Malaysian case. But the judge in this Malaysian case did use the words physical and mental wreck, that a termination of a pregnancy under Malaysian law can be undertaken if it is for the purpose of preventing the mother from becoming a physical and mental wreck. I disagree. I don't think that is correct. And in fact, Indian writers had made the point that the English requirements are far less exacting than the Indian, and therefore also the Malaysian requirements. So here, Dr. Nadesan was found guilty because there were no sufficient grounds in medical terms for termination of the pregnancy. To give you more details, let's look at the next one. The defense expert was a professor of obstetrics and gynecology. The mother had suffered varicose veins during her first two pregnancies. After the birth of the second baby, she underwent a tubal ligation as she did not want any more babies. The procedure failed. She became pregnant again later. The condition of varicose veins had worsened during the third pregnancy. The accused obstetrician gynecologist undertook termination of the pregnancy. The court rejected his stated justification, supported by his expert, that the mother was at risk of suffering a pulmonary infarction as a result of the varicose veins. Right, so then there were experts who gave evidence for the prosecution, and the judge weighed the evidence. While I say that the learned judge on the facts and on the law came to the correct conclusion that a criminal offense had been committed by the obstetrician and gynecologist, I say that the judge had not noted this important point, though it did not have a bearing on the case in Malaysia. And that is, in England, there was a lighter requirement about termination of pregnancies. Let's go on to the
Mr.
next one.
Ranjan, sorry, can we
Yeah.
go back to the last previous slide, please?
All right, let's go back to slides.
Okay. In this case, can the woman sue the person who actually performed the tubal ligation?
I mean, for a failed procedure.
That's
Well,
right.
Well, you see, of course, then we come to this. If it is a patient standard, was she warned of the risk of failure?
Oh, okay.
All right. If she was warned of the risk of failure and then went ahead, she can't sue for that. If there was a technical issue, say, about the performance of the tubal ligation, say, if it was, say, badly performed and that is why it was doomed to fail, then she can sue as regards treatment. So, yes, there is a possibility that she could sue. I won't go beyond that.
Okay.
Right? Let's go that go to the next. Yes, there were changes in the law regarding termination of pregnancies, and some years later, and this is how it is worded: a medical practitioner registered under the Medical Act. I mean, the law regarding illegal termination of a pregnancy does not apply to a medical practitioner, etc., who terminates the pregnancy of a woman if such medical practitioner is of the opinion formed in good faith that the continuance of the pregnancy would involve risk to the life of the pregnant woman or injury to the mental or physical health of the pregnant woman greater than if the pregnancy were terminated. So they had loosened the strict requirements here. That was a change made in the law. By the way, initially as the law stood under the Penal Code of India and Malaysia, anyone can perform a termination of a pregnancy. It need not have to be a doctor. But with this change in the law, only a doctor may perform the procedure. A layperson cannot perform the procedure, even if acting in good faith for the purpose of, say,
Saving a life.
not saving the life or,
Preserving the life.
etc. Okay, so, right. So there be some change. Now, in countries like India and Singapore, there have been loosening of the rules regarding termination of pregnancies. Let's go on to the next one. A Singapore case. How many of you can pronounce the name? Kadamanal Tarayil. I practiced pronouncing it. That is his family name, Dr. John Benjamin Kadamanal Tarayil. He was convicted to the district court of using criminal force to outrage the modesty of a young woman whom, in the presence of a nurse chaperone, he had examined for the purpose of an insurance application. She made an allegation of excessive examination of her breast. On appeal, the doctor was found not guilty. There was defense expert evidence regarding the need for the examination and the technique employed by the doctor. And that expert evidence helped to cast a reasonable doubt upon the prosecution case. There was an expert for the prosecution as well, but the Chief Justice weighed the evidence and he was unwilling to accept the prosecution witnesses, expert witnesses' evidence. Let's go on to the next one. This is what the Chief Justice said. Unless the expert evidence shows that one method of doing something is definitely and completely wrong, so that no doctor in his right mind would do it in the manner done by the accused, the court would find it very difficult to say that it is certain beyond any reasonable doubt that what the accused doctor did was not only medically improper, but was not done bona fide as well. In this case, the prosecution's experts' evidence falls far short of this. keep in mind, please, in a criminal case, the standard of proof for a successful conviction and for a successful prosecution is beyond any reasonable doubt. Whereas in a civil case, it is on a balance of probabilities. Let us go on, but let us look at the other Singapore case. The same Chief Justice. This is what he had to say about the case of Ng Huat, public prosecutor, where a patient went for an X-ray on his left wrist and the radiographer used the pretext to examine his genitals and anus. So that was clearly not defensible. Next one, please. I'd like to come to this, a miscarriage of justice. I appeared as counsel for Dr. Su Fukman. And I say a terrible injustice was done to him. In this Fu Fiona case, the claim succeeded in the federal court. Now, the judge who gave a name to the judgment, right, she gave her judgment 4 years and 7 months after the conclusion of the hearing in the federal court. The Court of Appeal had decided in favor of Dr. Su. So Madam Justice Siti Noma retired on 5th January 2007, just a week later. So we applied for the federal court to undertake a review of her decision. 5-member panel said that was a very telling point. They saw that there was something troubling, I thought. Usually only 3 judges would sit for a full hearing, but a 5-member panel. But they dismissed the application for review. The presiding judge merely said, we won't exercise our discretion. They did not give any grounds of decision. What happened there? Let's look at this one. The next slide. It was noted by the federal court in error that in this case of spinal surgery undertaken on the patient was a victim of a motor vehicle accident. Consent to the surgery was taken from her when she arrived at the hospital's admission counter, even before she had been seen by the defendant surgeon. What nonsense, I say. She met with a road accident, she was taken to the hospital, and the federal court wrote in its judgment that the consent was taken at the registration counter. If that was the case, I don't think we would have wanted to defend the case, because that kind of a consent would have been useless. This was an untrue statement put in by the federal court. Next one, that it was, quote, before let's go to the next bullet point, the previous slide, go back to that. Previous slide, let us go back to that, that it was, quote, not disputed, unquote, that the quadriplegia suffered by the patient was caused by a wire loop which was inserted by the surgeon and was compressing the spinal cord. That again is not true. The patient alleged that there was a wire loop. The surgeon said, no, the wire loop did not cause compression of the spinal cord. And yet the federal court said that both sides agree that the wire loop was compressing the spinal cord. If that was what both sides had agreed, we wouldn't have defended this case. We are not that stupid. This was an insult to the intelligence by the federal court in its judgment. Let us go on to the next slide, please. After the Fu Fiona decision, the Court of Appeal sat in another case, and the presiding judge was the same judge who sat in the Fu Fiona case in the Court of Appeal. And this is what he said. Questioned the correctness of the judgment of the federal court in Fu Fiona, quote, on the actual facts of that case, unquote. Next slide, please. So, what did the federal court say? Facts not disputed? The second bullet point, this is where we say, the cause of the patient's paralysis as being caused by surgery was disputed by the surgeon something expressly noted by the Court of Appeal, which said, and I quote, to recapitulate, the plaintiff's case is that she suffered paralysis because of Dr. Su's negligence. Dr. Su had denied this both in his pleaded case and in his evidence, unquote. Let us look at the next one. The surgeon, Dr. Su, said that the paralysis of delayed onset was caused by a spinal cord injury suffered during a motor vehicle accident. So what had happened is the motor vehicle accident had taken place. It was taken to the hospital. Various procedures were attempted to correct the bilateral locking of the facets. No, it was a whiplash injury. Then finally, Dr. Su had to perform reduction. And after the operation, that's when paralysis occurred. But that paralysis was not caused by the operation. It was a vascular infarction which caused paralysis of delayed onset. And that is how the case developed. A vascular infarction of the spinal cord arose from the accident, leading to paralysis of delayed onset. In court, the plaintiff departed from her statement of claim and alleged that neurosurgeon Dr. Mohandas, he had died by then, had told her that the wire compressing the spinal cord has caused the paralysis. Look at bullet number 4 and compare it with bullet point number 2. But plaintiff had said before the case started in court, she suffered spinal cord injuries in the accident. And then in court, she said it was a wire inserted by Dr. Su. Look at the last bullet point. The allegation regarding the wire was not pleaded by the plaintiff in the statement of claim. It was raised only at the trial, long after Dr. Mohandas had died. Let us go to the next slide. There is no report or note written by Dr. Mohandas supporting that allegation. The plaintiff admitted that she did not ask Dr. Mohandas for a report to support the allegation for a number of years. If she thought that was the vital bit of evidence, she should have got Dr. Mohandas to write a report. So contrary to what the Court of Appeal had said, see above, the federal court stated as, quote, not disputed, unquote. Look at this. Quote, following his examination, Dr. Mohandas did a myelogram test on her on 5th August 1982, and he found that the wire loop which was placed to correct the dislocation of C4 and C5 vertebrae during the first operation was pressuring the spinal cord, and that was the cause of the total paralysis, unquote. Again, this is an insult to the intelligence. The federal court put this in. That we were defending this case despite all these undisputed points. So, next bullet point. The statement by the federal court referred to something allegedly from a dead person. It was something alleged by the plaintiff to have been found by the later deceased Dr. Mohandas, who himself had not written anything to that effect. And you know, how would surgeons remember years later if Dr. Mohandas had been called to court and if he had said, I think there was a wire compressing the spinal cord? What would counsel have asked him? Where are the notes? Why didn't you write a report on it? Let's go on to the next slide.
Okay, Mr. Ranjan, can I ask you, if the patient who accused the doctor of all this, okay, this evidence that she's putting on about the wire and all, is it from the lawyer themselves or is it from the patient?
The patient herself said it.
Yes, but how would she know? Is she so educated? Is it planted onto her?
I won't go into all that. She said it, but we say it is not true.
Okay.
Right? It is not supported by the medical records at all. What was her case in the statement of claim? She suffered spinal cord injury as a result of the motor vehicle accident. So, what was the result of that spinal cord injury? Paralysis of delayed onset. It's a well-known phenomenon. Look at this. The expert evidence showed that the wire could not have compressed the spinal cord. What did the plaintiff's own expert, Dr. N. Arumugasamy, say? Quote, from the reports, I could not determine the cause of the paralysis up to 20th July 1982. The first operation was performed on 19 July 1982, and it did not state elsewhere the cause of the paralysis after 20th July 1982. Look at that. And he also said the wire could not cause injury to the spinal cord if the wire is used under the lamina. It will not bow very much. Let us look at the next slide. The surgeon said without challenge that he did pass the wire sublaminally. So, going by the patient's expert's opinion, the wire could not have compressed the spinal cord. And what did the anesthetist say? During the operation, quote, the blood pressure and pulse remained regular. And, quote, nothing untoward showed, unquote. She also said, quote, if the patient's spinal cord is compressed during the operation, the blood pressure would drop drastically, unquote. Look at that. The anesthetist says, I did not see anything unusual. The surgeon's expert said, quote, the chance of the wire coming into contact with the spinal cord, very little. It could not cause compression. Let us go on to the next one. The surgeon also said that he undertook a second operation, an exploration of the spinal cord some days after the onset of paralysis. He said, quote, the wire was intact, has not shifted, has not broken. The exploration showed the block in the myelogram. It was the swelling of the spinal cord which was caused by the original accident, that motor vehicle accident, unquote. Look at that. His finding. Let us go on. Now, the plaintiff's evidence regarding the date on which she signed the consent form. Remember, federal court said she signed the consent form at the counter, registration counter. Question. I put it to you on 15 July 1982, you gave a written consent to a performed reduction. Answer, yes. Let us look at the next slide. Therefore, she signed the consent form in the ward 3 days after admission, not at the admission counter on 12 July 1982, as said by the federal court. Did the federal court think us as fools? Okay. When there was a consent signed by the patient 3 days later, and they thought we were fools to have gone and fought the case in court? If the form, look at the second bullet point, signing the form at the admission counter would have been unacceptable and would have amounted to negligence. No decision yet about surgery, no advice and information regarding surgery, etc. And the federal court thought that we decided to fight this case. If this was indeed the truth, let us look at the next one, please. The federal court also appeared to doubt at paragraph 30 that the plaintiff had actually consented to the second operation for an exploration after the onset of paralysis. Let us look at this one now. Next one, let us look at it. But this is what the plaintiff said. I am suggesting to you, questioner, I'm suggesting to you that before the second operation, you knew the second operation was a major one. Answer, yes. Question, you gave consent to this? Answer, yes. You thumbprinted the consent form? Yes. Do you agree if you did not give your consent, Dr. Su will not operate? Yes. So what did the federal court do with all this evidence? And they came up with something which was not even in evidence. Oh, doubting whether there was consent to the second operation. Let us go on. The conclusion. Negligence was found on the basis of matters which were not even in the evidence. Negligence was found contrary to the evidence. Let us look at another case, also of an injustice in which I was counsel for the plaintiff, Zul Hasnima, and her baby. It has been described as a landmark case in regard to the application of the Bolam test in medical negligence. Landmark case. I will also say, regrettably, it should be notable also for the obstetric expert evidence tendered in support of the defense to the claim, which involved massive brain damage suffered by a baby by reason of a hypoxic ischemic insult at birth, the fetus being dependent on the mother's blood circulation for receiving oxygen. The attending defendant obstetrician's stated intention was to perform a cesarean section if the mother, who was at 36 weeks of gestation, had gone into labor. At 36 weeks, she was borderline, Next one, please. Let us look at this. It was therefore crucial for a successful defense to establish that the mother of the baby was not in labor at any time before she collapsed, undisputably because of massive bleeding. Following the collapse, it was then that an emergency cesarean section was performed, the baby being born in a very ill state. An emergency hysterectomy too was performed so as to stop the bleeding. It was a plaintiff's case that the mother was in labor for some time before her collapse, and that a cesarean section should have been performed without delay, certainly before the collapse could take place. In that way, the baby would not have suffered loss of oxygen in utero by reason of the massive bleeding suffered by the mother upon collapse while awaiting the delayed cesarean section. So please keep in mind, this was the mother's case. She was in labor. But let us look at the gymnastics performed. Fantastic gymnastic display. Let's go on. The defense obstetric expert, Dr. Raman Subramanian, while under examination in chief by learned counsel for the obstetricians, Mr. Darrell Goon, let slip the truth with these notable words of admission regarding the mother. In this patient who was in premature labor. I'm sure he meant what he said. In his expert report given before trial, Dr. Raman wrote, quote, the pain was thought to be due to labor. He also wrote in that report, she was given Bricanil in an attempt to stop labor. As you know, once labor starts, it may progress, it may not progress, but Bricanil was given. Next slide, please. Let us look at it. Mr. Goon for the defendant obstetricians asked the plaintiff's expert, Dr. Ong Hian Chun, during cross-examination, do you agree that she was in early stage of labor? Dr. Ong happily and readily replied, yes, because these were own goals. They were destroying any defense case that was available. The question and answer were truly significant. Let us move on. Following such own goals by the defendant obstetricians and Dr. Raman, they made a 180-degree turn. The mother was not in labor, they claimed. Dr. Raman moved from his earlier position and insisted on the cross-examination that she was not in labor. What was he smoking earlier? Let's move on. Let's move on to the next slide. So, and the defendants succeeded in getting the claim dismissed. Not in labor. That was the conclusion drawn by the court. None of the 9 judges who had heard this case as it wound its way up into the federal court had addressed this point regarding the, quote, own goals, unquote. The regrettable final result, a little girl who was born following a mother's collapse, a horrific incident, according to Dr. Raman, had suffered severe brain damage, is maimed for life, and is without compensation. Is this what justice is all about? Let us move on. About the issue of a court not addressing a point which has been raised, especially by an eventually unsuccessful party, it would be instructive to see the judgment of the court in the landmark case, Khalil and Carbolic Smoke Ball Company. a case very well known to law students. They learn it in first year. The court addressed each and every one of the amazing number of points of law covering many important parts of the law of contract, which were raised ably but unsuccessfully for the defendant. See, it has been said, the most important person in court is not the judge. It is the person who loses. That person must go away thinking, I have received justice. The points that I've raised have been considered carefully by the court, and a decision has been made, even though I don't like the decision. Let's go on. What are the points to take away after all that I've said? There will always be some wrong decisions. Judges, lawyers, litigants, and witnesses must work at avoiding the making of wrong decisions. The healthcare professions have a vital role to play in the administration of justice, the protection of the vulnerable, the provision of various social, economic, and business services, etc. And I bring up this point now. Let us look at this by a professor of psychiatry. It is a personal communication. What do lawyers want? The truth or a conclusion? I would like you to think about this. Sometimes I hear this from doctors. They complain about how lawyers give them a hard time. I would like you to think about this, how doctors can give others a hard time. Think about what happened when Roy Meadow went around attacking a number of women in his evidence. Think about that, please. Think about how an injustice can arise. How on earth, in the Fu Fiona case, could the federal court come up with such a judgment? Brushing aside vital questions of law and fact, how could it be that in the Zul Hasnima case, when it was already taken up by the other side that the mother was in labor, that they can be allowed to change their position so dramatically and convince the court that the mother was not in labor? They cannot plead insanity or something, when they said all these things earlier, that they were not in the right mind, and therefore should be forgiven. So may I also say, therefore, if you feel sorry for the medical profession, please feel sorry also for lawyers. I hope you'll have some sympathy for me. Thank you.
Thank you, Mr. Ranjan. Okay, there is one question. So you didn't win these two cases despite everything?
Were we helped by the doctors there?
Yes.
Now,
no.
In the Fu Fiona case, right, the medical and expert evidence supported us. In the Zul Hasnima case, there's more of a challenge. But my point is, what kind of challenge was it? An unworthy challenge to our case. The mother was in labor.
Can I ask you, as a doctor, if I were to be called to say something against my fellow colleague, where would it put me? A hard wall and the difficult.
You must work for the truth.
So do
the
lawyers
truth is far
want
more
the truth
important.
or conclusion? You yourself ask, you want the truth or the conclusion?
Yes. Now, just imagine, we had a medical negligence case in the Johor Bahru High Court, where negligence was found by the judge. One of the experts for one of the defendants admitted in court that he will not give expert evidence in support of patients, even though they had a good case.
Mm.
He said, out of loyalty. No, he was talking like that. So do you expect judges to respect doctors when they talk like that? What do you think this is? A mafia?
It is very difficult. Yes, I agree.
But I'll say this, don't think that the medical profession alone is like this. If you want, I can give you 1 hour lecture on what the legal profession get up to in protecting its own kind. Right? Lawyers too can be guilty of such things, protecting their own kind.
I don't know why. Well, behind their back, a lot of doctors are stabbing each other, but when it comes to court, they're always supportive of each other.
No, let me put it this way, that the higher duty of doctors is to justice. Don't patients deserve justice? We have seen this often enough. Right? That doctors have not helped patients who deserve justice, who deserve decisions in their favor.
Okay, can we take just a few questions, please?
Oh, I doubt, I mean, I'm doubtful about taking questions. I know there were some questions given in advance.
No, we'll take the questions here.
Which ones are you?
Okay, Mr. Dr. Low said he's seeing a 19-year-old with who's an intellectual disabled patient with RVD disease, which brought in by the brother request for treatment. He is stable, not in acute illness. Can the parents sue me if I start him on a medical treatment without the parents' knowledge? A 19-year-old who is intellectually disabled, brought in by the brother. So what right? Ayo, that's a very difficult case.
It's a complex point, all right?
Yeah.
It's a complex point. First of all, the age of consent, going by the authorities in Malaysia, is 18 years. But I find it a silly point. People think that the age of majority is the age of consent. That is not the law. I've been saying it for years. Nobody's been listening to me.
You said that when you actually gave us a talk last year.
Yes. Yes, I've said it before. The law of consent in Malaysia is in a very jumbled state. Now, a few things. We have a Mental Health Act. It is recognized in the Mental Health Act that patients who are mental patients can give consent in certain situations.
But this is not a mental patient. This is an intellectual disabled patient.
Yes. So I'll put it this way. The doctor has to form an assessment. Is the patient able to understand? Sufficient understanding, sufficient intelligence, so as to make a decision. If the patient does not have that understanding or intelligence, then of course the mental health legislation will have to kick in.
Okay.
Now, let me give an example. UK case, 67-year-old prisoner who was suffering from schizophrenia, was a diabetic, and he had gangrenous leg. The doctors advised amputation for the purpose of saving his life. He refused. The case went to court. The judge took evidence from the patient. Mind you, a vulnerable person, prisoner, 67 years old, psychiatric patient. But the court, what's happening?
No, I'm sharing my QR code.
Yeah.
Okay. Go on.
So the judge decided in favor of the patient and said that the patient was entitled to give consent or to refuse consent, and his refusal must be respected. Right? So I think these are important, but I can't go beyond this. I mean, this kind of a question.
Yeah, just one more question regarding this Dr. Lau's. Now the brother, he said, is the eldest brother. So means
so what?
Than the 19-year-old.
what?
So it doesn't
So
mean,
what?
okay.
I'll
That's
say this, so what? But the way, some of this private healthcare legislation has been written, I'm a bit troubled, I think we should be more careful about all this.
Okay, it's been a long lecture. You must be very tired.
No, I am not. I'm just annoyed
Yeah, I can.
about what has been going on.
Okay,
I think that's about it, I think. At what stage can we criticize a judgment made by the court? Won't that be contempt, particularly federal court judgment? I think it is outrageous that the highest court in the land could come up with such a judgment. Civilized comment is permitted, but not to the extent, say, we tell that the judges are stupid. Mind you, I didn't say that the judges were stupid. I didn't say that they were, acting in bad faith. I didn't say that. Right? What I said was that this was simply wrong because it went against the evidence.
Yes,
right?
I think the worry about contempt is not for somebody like Mr. Ranjan or me. We will stop here and then we will again invite Mr. Ranjan so that Mr. Lau, if you are Dr. Lau, if you're sued, next week you will know what to do, because next week we will talk about what doctors should do when they get sued.
All right. Now, may I know?
Yes.
You see, I've seen in the chat here, there were some questions, etc.
Yes.
I won't answer questions through Docquity and Facebook, please. But if you decide that I should answer them, then forward them to me and give a written answer. All right.
Okay. So, okay, if you want, Mr. Ranjan will answer your questions through email, right? You wanted to do that, right?
Yes.
So, can I give the PSR?
No. I think send them to you. You forward them to me. All right. Can that? No, I would prefer it that way.
Okay, beating hearts .live ayo kacau lah ini @gmail.com. Okay, so anyone who has questions can send it to me. I will forward it to Mr. Ranjan, and then yeah. So I've already given for those doctors who can't scan the QR code, please send me your name, MMC and IC, and email to my number, which I've given just now, 012-712-3348. Okay.
All
so
right.
Two things: send the questions to my email. I will vet through it and see whether I should send it to Mr. Ranjan, and then send me if you can't scan the QR code. We will see Mr. Ranjan next Wednesday. Ranjan, I will see you next Wednesday.
All right. Yes. Okay. Thank you.
Won't be so irritated. You will be funnier. Last year you were funny.
Well, I wasn't irritated with anybody who participated today. All right. Let me assure you of that.
Oh, of course.
So
but you did some.
But I am disappointed, right? Dr. Su suffered a grave injustice. In Zul Hasnima, mother and baby suffered a grave injustice, I say.
I think it's because of our cowardice. We're too coward. Yeah. We are not courageous enough.
Yeah.
So we want both.
There's still some more what on chat. What are they saying?
They're just saying thank you, Mr. Ranjan.
Oh, I see. Okay. I thought they were arguing with me.
No. Nobody dares to argue with you.
Please.
They just say thank you.
Okay. Oh, okay.
That they are able to scan the QR code. Okay.
All right. So thank you then. Okay.
Thank you.
Okay. Bye.
Bye.